I'm Cole Dudley, Director of Industry Solutions for SCRA. It's my pleasure to welcome you this morning to part 3 of the U.S. Patent Office webinar. This webinar series is being sponsored by SCRA and the Kim Lahey law firm, and we're pleasure to welcome you this morning. We have a very special program for you in part 3 of our series. I'd like to remind you that this is being recorded and that the recording will be sent out to you later today. Also, please remember to enter any of your questions at the Q&A button, and we will get through them at the end of the webinar. Now it is my pleasure to introduce our 2 speakers today. First, we have William Vaughn, who is a supervisory patent examiner with the USPTO. Great honor for us to have William with us today. He spent 23 years with the Patent Office. He has a great deep technical background, starting in memory and multi-computer data, and later getting into video recording and compression. He has been an educator and an outreach person with the Patent Office for many years, worked with over 20 universities. He also advises individual inventors at workshops, so extremely well qualified for what we're looking for here today. And in a conversation with him, I have to tell you, it was a very, very pleasant introduction to the Patent Office. He was talking about how important this job is, how it affects so many people's lives, and how he really looks forward to working with patent attorneys and clients to help them find a way to get a patent. So it's not an adversarial relationship, it's a partnership. And it was very refreshing to hear that. Our second speaker today is Doug Kim. For those of you from South Carolina, and particularly the upstate, you probably know Doug. Doug has founded his own firm, Kim Lahey Law. Very well-respected patent attorney, has won multiple awards for best lawyer, best intellectual property attorney in the upstate. And Doug focuses on a broad range of intellectual property issues, not only patents, but trademarks, etc., and takes a very strategic approach to working with his clients. And some of you may not know that he actually has a degree in physics and started out as a computer programmer and software engineer. So he has a business background as well as being a patent attorney. So today, I am going to let these 2 gentlemen talk, as they're the ones that can help us out and inform us about the patent world. Doug, would you like to start by telling us, when someone comes to you, what they should expect out of that first meeting and how they should prepare?
Oh, absolutely. There's a whole process that occurs before you get to filing and drafting the patent application. It involves several steps, and they're all important. So I'll sort of go at them in no particular order. One of the first ones is, who's the inventor? So inventor is, and one of the requirements in the Patent Office is that the inventors have to be named on the patent. To determine who an inventor is, it's the person who conceives of the idea. It's not necessarily the person who builds the prototype or who implements the idea, but it's somebody who thought of at least a component of the idea or the invention as it shows up in the claims. We'll talk about claims later. That's for the next seminar. Something that's very helpful when we do intellectual property protection, for the most part, we're in the commercial setting. And when we're in the commercial setting, we want to answer questions. What problem are you trying to solve? Who's your customer? Who's potential competitors? What is the actual invention itself? One of my favorite examples to use is the rollerblade and the roller skate. If you really think about those 2 devices, the rollerblade and the roller skate aren't that different. One of them's got wheels on trucks that are linear side by side, and the other one's got them in a straight line down the center. but the boot, the plate, the laces, bearings, a lot of similar components. That invention was insanely popular because customers accepted the fact that, wow, we can actually do some of the things that you can do on hockey skates on rollerblades. So it was solving a problem of, I can't perform as well on roller skates without this type of configuration. Well, then we start thinking about, okay, who's the customer, who's this going to be distributed by, who potential competitors are. So when we draft these applications, we want to do it with a business sense in mind. So one of the things I always ask the question is, okay, and I don't mean this to sound cynical, but I say, who's going to buy this other than your mother? And then we start getting into this concept of what's the commercial valuation? How does it fit your business? Does it support your business? The best part about intellectual property, at least for me, is it's one of the very few areas of law to where what you get out of it, a patent protection, trademark, copyright, what you get out of it is actually can be worth more than what you paid for it. And with all due respect to the legal profession, that's not often the case. But in this particular case, it is. We build a tremendous amount of value in intellectual property as a nation. It supports businesses, it creates jobs, it protects markets. It's an incredibly important, and William stressed that in our initial phone calls with this, and it's very refreshing when we say the Patent Office understands how serious this job is. With that said, though, there's this whole preparation and you can do this by yourself, and you ask these questions: who's the inventor? What are you solving? The commercial applications. It is not required, but it is recommended you use a patent attorney or a patent agent, because this can get technical, particularly with the way what William's getting ready to talk about. And when we're negotiating patent application and patent protection with the USPTO, the Patent Office, which is how we think of it, we would rather be focusing on what makes this patentable, what makes this application allowable. We would not like to focus on the technicalities and some of the legal requirements, because patent law has been around for 200 years plus. It has been around. There's a lot of law and a lot of administrative requirements that William would get into that we have to do. We want to get past all that and get into, all right, what is the invention? So with that said, I'm going to turn this over to William, although I may interrupt him periodically, and let him walk through the different types of patent applications, the process, and how this is perceived at the Patent Office. And I will leave you with this. It is an honor to have somebody like William to do a presentation like this, because we just don't get to have conversations with the Patent Office in this manner that often. And this is a real treat. So with that said, William.
Well, good morning, everyone, and thank you, Doug, as well as everyone that's online. Truly appreciate this opportunity to sit down and give somewhat of a brief overview of what the process is on our end in terms of the information that we receive from you, as well as providing information to you regarding that process. As Doug stated, it is it's so important for and not trying to be an advocate on either side, but in terms of the process of when you are putting together an application, as whether you're an independent inventor or even a somewhat small company, having representation, even though we never advocate specific representation to anyone, but this process can be very detailed and very technical, as Doug stated. So it's important in a lot of ways to have individuals that are able to help walk you along that process, because and it also, in my opinion, it's the examiner's job also to be a part of that process too. So if we can go to the next slide, and what this is going to be, somewhat brief in terms of what I'll be presenting today or this morning regarding the differences between non-provisional as well as provisional type applications, and I'll try to give a little brief overview in terms of the contents of the patent application, what's involved in in terms of the detailed description, the drawing, the abstract and claims, and then the requirements for enablement. And so all of these are very important. And I'm sure this being the third webinar, you probably have gone through the process of what you need to do prior to that. Searching. I'm sure Doug is probably he may go into discussion regarding what you need to do in order to prepare for this particular step that you're going into. So if we can go to the next slide. And I'll be going back and forth, and I will also add a little caveat in terms of if there are any questions that you have that I may not be able to answer. I have provided within the slides my email address. I will make sure that any questions that you might have that I may not be able to get to, I will put you at least in the right direction, or I will at least try to get an answer for you. So one of the things in terms of the types of utility applications is, and again, utility, it has to have some type of use. So one of the things you have as an inventor or a potential filer of an invention is, or application, I should say, is a provisional application. And what this affords you as an inventor or an applicant is an opportunity, and Doug has probably heard this term before, almost like putting a marker in the sand so that you can receive coverage back to that particular filing date. Now, within that particular time period, you have 1 year, a 1 year limit to be able to kind of work out the kinks in terms of marketing. Maybe you are dealing with some design things that you will be working with, working it out with whether or not you have an attorney. But you also want to remember in terms of when that provisional application is filed, and I'm sure, again, Doug will probably touch on this, whatever you put in there in that provisional application, you have to make sure that no modifications will be made within that description. So it is important to put in whatever you feel is necessary that goes into detail in regards to your particular invention. It is placed in there within that provisional application. Now, the requirement is you don't have to have claims. The case isn't, the provisional application isn't examined. It just affords, in some ways, just to put that marker in the sand so that when you apply for your non-provisional application, you will be able to, if the case is eventually allowed, it will give you coverage to that particular date. And many times you will see, as an examiner, it helps the examiner, I should say, in some ways, in terms of making sure, because the date is so important on the examining side, in terms of when an examiner is trying to find information, or as we quote unquote call it, prior art, in order to apply to your particular invention. So that date is important to you. So, but you want to make sure within that particular time frame, that 1 year time frame, you're working out whatever type of, marketing that you'll be dealing with during that time, in anticipation of filing your non-provisional application. Now, once you get, and you can go to the next slide. Mm-hmm. So what we can talk about in terms of, because I don't want to take up all of the time to give Doug an opportunity, because we're going to also have a question and answer. So the specification, whatever you place in that specification, make sure that when you're writing your claims, and we'll touch on that also, that it coincides with whatever is in the specification. It is essential that you provide all the details that fully explain, enable your invention for one of ordinary skill to make or use your invention. Now, it's a one of ordinary skill. That's essentially, in so many words, a person that has the normal capabilities or technical expertise within that particular area. Now, I can recall maybe when I first became an examiner, I had one of a person that I was reporting to, a primary examiner. He had been with the office for probably like 20-something years at the time, and he would often say, "I'm above one of ordinary skill. I'm at the genius level," and he would often tell me that, and it would make me laugh. But a person of ordinary skill in the art that can make or use your invention. So you want to make sure that your invention is very clear, concise. Now, even though an individual can utilize terminology, be their own lexicographer, they can, at the same time, you want to make sure that those words, those terms that are being utilized coincide with the particular technical field that you are saying your potential invention falls under. Because, again, the examiner, on the examination side, the examiner is going to be utilizing, in order for them to get a good understanding of what your invention is about, they need to, it has to fall within the realm of that technical field. And again, they're going to be utilizing not only the particular terms that you have provided in their invention, they will also be using a broad range of other terms that fall within that particular technical field. So you want to make sure that it's very clear, concise, to where one of ordinary skill is able to utilize that particular invention. All right.
William, one point I want to make here is that when you're working with your application or you're working with a patent attorney or agent, think about not just your invention when we're doing the drafting part, but we also ask, well, how else could you make it? We want to think of as broadly as we can of what possibilities are in the specification. And as William, I'm sure we'll talk about soon, is they've got this application and the patent office, and that's all they have. The argument, but that's what I meant, I know I didn't write it down, does not work. That's just not going to happen.
You're absolutely right, Doug. And it's important to put as much as you can within that application, because what will happen is, and I've had times when I've sat down, in environments like this, maybe talking one-on-one with an independent inventor, where they have come up with, they filed their provisional application, but it's very bland and it doesn't really go into everything. Not thinking ahead in terms of maybe there'll be other applications that will fall, that they will possibly fall based upon that particular initial application that they've filed. So it's important to make sure that you put as much of what, we call it everything but the kitchen sink in there, as long as it falls within the realm of what your invention is about. But don't be so detailed to the point. And what I mean by detailed, just so narrow in terms of leaving things out that you may have potential to maybe file other applications off of it. And if that's what you're saying, Doug, I'm in total agreement with you.
That's exactly right. And there's an art to this, and it's a balance. But having a full understanding of the invention, and I'll get in the weeds just a little bit. Using the word fastener is appropriate. Using the word a threaded Phillips head screw, too narrow. So that's the kind of conversations we have.
Absolutely. And at the same time, an inventor may have, again, and Doug will probably go into this, different type of embodiments within that particular initial application. So if we can go to the next section, okay, the field, and this is again the background of the invention, where you're essentially just giving, and as it states here, you're just giving a high level overview of what the particular field of your invention is. And this is important also because the examiner, again, the job of the examiner is really to have this type of information that will help walk them through to the basic understanding of your invention. Okay, so it gives them that amount of information, as well as gives you, where you're describing any type of related prior art. So, and it's also important that if you have that information, you know, and as a patent attorney, you'll be, and I'm sure Doug will talk about this in terms of making sure that you include the IDS, any type of prior art that is known. You should be able to, you should provide that, you know, even make note of that in the description of the related art within that particular application. All of this information enables the examiner, using that term enable, for the examiner, gives the examiner the information that they need in order to properly understand what your invention is all about. You know, describe the related prior art, the particular field of invention. You can go to the next slide. Okay.
One
so
of the requirements that really is, it's not just a legal requirement, but it's so important for validity, is that if the inventor knows of something that could potentially be the same or similar to this, we not just have the legal obligation to disclose it. If there's ever an attempt to enforce this patent, if it's granted, trust me, the other side's going to find it. So we're better off getting the examiner to know about it and granting the patent than not. We really want to have a patent that issues where everything that we know of is considered in the granting of that application.
I totally agree with you. And in terms of, you know, because the office wants to make sure that we issue valid patents, plain and simple. And I emphasize this to my examiners quite often in terms of when we are moving something to issue, make sure that you have covered every particular base that there is in order to provide, you know, to make sure that, at least on our end, within our little area, that we've done everything that is necessary to issue a patent that we feel, meaning that within my particular area, that is valid. And I'm sure any supervisor and an examiner, that is the goal. Yes, we want to make sure, you know, it's great to issue patents. It's more important to issue valid patents. So again, when you're with the brief summary of the invention, you know, again, at a very high level, you want to also describe the problem that your particular invention is going to solve. And as well as how one of ordinary skill will make your invention. Provide the detail for one that can understand how to do this. What does your invention do? Another thing is your drawings. In certain technology areas within our office, the drawings are essential. You know, I told Doug as well as Cole yesterday, my brother's a patent attorney, and he worked in the razor blades area. So those quad razors that men are using to this day, I remember him working on those in the late 90s, early 2000s. But those figures, those drawings were essential, he would often tell me. Now, I'm not saying in other areas it can be the same thing. In my particular area of video compression, or recording, networking, those figures help guide the examiner. And I'm also looking at it in terms of, you know, how it helps the examiner use the information or use those drawings in order for them to best search their invention, your invention, in order to provide the right type of office action, a clear office action, so that we can move your application forward to whatever, whether it's to the board or whether it's to an allowance. So those figures are essential part, in my opinion, to the overall scope of your patent application. Go to the next one, please. The abstract. The abstract, and this is, I'm not going to touch too much on it. Single paragraph. I'm sure many of you have seen patents before, and that little abstract gives just almost like in some ways, a little brief summary of what to anticipate within this patent application, in terms of the technical field. And examiners utilize that when they are getting an idea of what this invention might be about. And also for any other for others that are looking at, and it doesn't necessarily mean just for the examiner, whether it is any individual, again, one of ordinary skill, they want to have an idea what this invention is all about initially. That abstract helps, as well as the title. Now the title, and we can go to go to the next slide, please. Okay, but I'll touch on the title quickly. And the title, a lot of times one of my pet peeves as a supervisory patent examiner, as well as being an examiner, I prefer to have a title that in a lot of ways can hit on what initially that invention is all about, because it helps me when I search, if I have to go back and search other patent applications. And many times, when I see patents that have a system, it. Okay, I think I have a question. Okay. I'm sorry, Doug. I'm reading the question.
Yeah, yes, the question is, William, you stated the provisional could be complete. However, it's quite often the case that inventions are perfected during the term between when the provisional and the non-provisional is filed.
Mm-hmm.
It is this attendee's understanding that the contents of the provisional may be incorporated by reference thereto, but more can be added when the non-provisional is filed during the provisional as a platform. That's true.
Yes.
Yeah, so if the provisional is filed January 2020 and then improvements are made, a provisional December 2020 can be filed. That can include the subject matter of the provisional, as well as everything you developed up until the point of filing the non-provisional.
Mm-hmm. But you want to make sure, and Doug knows this as again well as I do, again, that the body of the application or disclosure does not draw away from that, where you are essentially adding something that is totally different than what you initially placed in your provisional application. Because believe you me, when I know when an examiner may utilize a provisional application in terms of utilizing that date, the first thing an attorney is going to do is, and Doug, if I'm wrong, I want to make sure I say this right. Most of the time, an attorney is going to go back to that particular provisional application to make sure that the disclosure coincides with what's in the non-provisional.
That's correct. When we're trying to defend against patent infringement, we will go look at that and say, hey, this wasn't in the provisional. You don't get that early filing date, and that can create some problems for the patent owner.
Absolutely, absolutely. So Doug, I don't want to take up all the time. And maybe within the other slides that I have, we'll probably in our overall discussion touch on those things. So I'll leave the floor to you so that you can go ahead and go through your slides.
Well, actually, your slides are fine. Candidly, with all due respect, what I'm going to do is just start asking you questions, because again, this is such a treat to be able to have somebody. I don't mean this the way it's getting ready to sound. To have somebody on the inside to talk to. Yeah, going back to the drawings, I've heard several examiners say, just as you did, they're critical, and having a real good set of drawings really helps you with the understanding the invention and the examination, even though the claims are what you're really examining. Can you give us some insight about the difference, the same application, one with a good set of drawings, one with candidly a bad set of drawings? What's your take on that?
Well, and you've seen this before, where you see you see, say, multiple applications with the same type of drawings,
Hmm.
exact same type, and it really doesn't add a lot of detail in terms of, because I think the drawings also paint the picture in terms of what your invention is all about. Because I know my examiners within our area, they utilize those elements, those specific elements, in order to show the teachings of what that invention is all about. Because and at the same time, those drawings still have to those specific elements of the drawing still have to coincide with what's described in the specification. So it really, again, I look at myself as also a visual learner in some ways. It really gives me, as an examiner, a full picture of what the invention is all about. Because when I diagram a claim, I actually utilize the drawings most of the time in terms of how I look at those claims. And when I diagram the claim, those drawings, I've literally pictured the drawings. Everything should coincide together, in my opinion.
I think that, and William, I remember back in the day when patent drawings were actually done with ink on paper. Today, I think that's rarely done.
Very rare.
But I think it is important to have a good set of drawings for the patent application. And I think sometimes I think that's not stated. I think that's understated. We've been talking mostly about utilities. William, if you could sort of give a brief overview. There's more than just a utility patent application. We have designs and plans. Can you sort of give us an overview of what are some of the other options to inventors?
In terms of you're saying in terms of whether or not they can, utility applications, design applications.
Yes, so sort of an overview of what they are and what, and within the office, my understanding is that the design applications go to a different set of examiners, plant applications, different set of examiners.
Totally different set, totally different type of examination process. Because and on the design side, you will see more models of a design application. I have walked in, on different committees that I'm involved in, where a person is a design examiner, and they will literally have the design, a mock of that particular design application. Now you don't see it quite often, and also in terms of on the utility side, rarely, very rare, probably less than 1% will, you as a patent attorney will bring in the actual design of that application. Now I've had, but on the flip side, I've probably 7 or 8 years ago, I've had individuals bring in, whether it's through a laptop with an inventor to show me what their particular invention is actually in more detail, describing it to me, as well as my examiner, to show me, to assist me in understanding their invention. So in terms of my knowledge in terms of understanding the design aspect of examining is not as detailed, but the process in terms of utilizing design when a design patent application is submitted, the drawings are essential.
They're the whole protection. So while we're on drawings, there's a couple of questions coming in about them. One of them is this, which I think is very interesting, and I'm very interested in this answer. Can an applicant submit a video clip if the drawings don't adequately capture the essence of the patent or the application?
I have never, to my knowledge, no. But again, going back to, I've had interviews, in-person interviews, where applicant has, along with their attorney, have submitted, have literally had me looking at their invention and describing it, whether it is a video clip. Now, with regards to my understanding in terms of policy, I don't think that you can submit a video clip as part of the actual package, patent application package.
Yeah, that's not there yet. And
No.
switch gears a little bit. We should have talked about this earlier. When we've been talking about utility patents in very general terms, we're really talking about the structure and the function of the invention.
Function, absolutely.
Yes. When we talk about design patents, we're talking about the aesthetic look.
Absolutely. Absolutely.
And yes, the example I use all the time is, and there's a bit of an overlap with trademarks and design patents, but the example I use with some frequency is based on how old the inventor is. The Coca-Cola bottle has a very distinctive design. The old school Coca-Cola bottle. It's a wonderful candidate for a design patent, and I believe there is actually one on it. For those that are older, I use the Crown Royal bottle because it has a very distinctive design.
Absolutely.
And you can see that one coming a mile away for those things. But that was one of the attendees request a clarification on that when it goes.
Absolutely.
Yes.
And I agree.
When we're talking about the background of a patent application, patent practitioners know not to do this, but can you sort of give your opinion on when, in my opinion, it's a bit of a mistake when the background kind of goes on and on about, let me tell you the problem I solved. Let me tell you where I was. Let me tell you about the family that was around me when I solved the problem. I mean, while the term background is a little bit misleading, explain what you're looking for with the background of the invention.
Yeah, and that's one of the things. And if we can go quickly to the slide, I got a slide that kind of addresses that. Some of the do's and don'ts.
Oh yeah, let's do those.
Yeah. Next slide. Next one. Okay. Yeah. So here's some of the do's. In terms of describing invention. One of the and go to the next the don'ts. The next slide. So you want to make sure that we don't need to know this invention will sell, make millions. We don't need to know all of those specific things in terms of just give us the particular environment that's necessary or that will lead to what your problem is trying to solve. I don't need to know, like I said, where you were, who was in the environment with you when you came up with that, because that's not going to have any bearing on how we're going to decide whether or not your invention is patentable or not patentable. But give us an environment in which that particular invention or potential invention that you have it falls under, that will also lead the examiner in gaining an understanding because most of the time the examiner, when they read that particular section of the background of invention, it actually puts the examiner in a place to where, okay, this is where I need to go when I'm processing or about to search this invention. I know exactly the field. I know the area that it might be classified under in order for me to begin to move forward in searching that particular invention. So a lot of times, and this is, again, not trying to advocate for patent attorneys or not, but those are the little things that, in my opinion, will help when individuals have advisors like yourself walk them through, because now we don't have to worry about making these type of modifications, modifications within your specification, what have you, in terms of things that really aren't needed.
I think the background's a good place to put the problem you're trying to solve.
Absolutely.
Because we'll use a famous case that William, I know you're familiar with, in the process of, if the background says taking a tire out of a mold is very difficult. So the problems we've had in the past are these. My invention solves these problems by focusing on this. And you don't really need to spend paragraph after paragraph, just sort of lay that out there. And so when we first started this presentation, we're very interested in what problem were you solving? Exactly. Why is this, what impact is this going to make on the world, commercial, or that field? And I think the background's a good place to put that.
Absolutely, and it should help lead us into whether it's an improvement on something else. But when you get to that point, then we go into really the detailed description and stating, okay, I'm going to give you the details of how I specifically will solve this particular problem.
That's right.
That
Yes.
is so crucial. Spending time on the things in terms of grammatical spelling or all of those things, and the examiner is going to go through that. They should go through that process, but the less time that an examiner has to spend on correcting these type of formalities gives them more opportunity to provide the amount of necessary time to really dig in and delve into what this claim invention is all about, so that we can at least move the application, your particular application, forward without having to go through a back and forth type situation of things that in some ways may not be as necessary if you have an application that is filed properly in terms of some of the informality, the little things. And again, that's the job a lot of times of that patent attorney, to kind of flesh out those things early on so that we can really get into the meat of what the invention is, and maybe to have a more broader, a more detailed discussion on claims and things that will hopefully move an application forward to allowability.
Yeah, there's a question. Does the USPTO have a template for inventors to complete and deliver to their patent attorney?
You know what? I actually, at the end of my slides, I have a link that really can walk an inventor through that whole process. It's on the last page, and it really the last link goes into great detail in terms of the from A to Z, the process of filing. Not even filing, just what you need to do pre-filing, what needs to be done in terms. And we talked about providing a checklist. I was going to try to do a checklist, but it was so much information where I think it would best be suited for you to go to the website, and it literally goes through each specific level of what you need to do in order to embark on this patent filing process.
William, I don't mean for this to be an advertisement for Doug, but could you talk about the advantages and disadvantages of an inventor filing directly and working with the patent office versus engaging counsel, and how that may look for an individual?
Great question, Cole. Well, again, we have at an independent inventor or whoever that is interested in filing, we have access to pro bono. We have pro se examiners that can help walk an independent inventor through that whole process. Now, I would say majority of the time, an examiner will know specifically whether or not the application is being filed by an attorney, a patent attorney, a licensed patent attorney, or an independent inventor. It's most of the time you can see based upon the structure of the detailed description, the way the claims are written, and a lot of times what the examiner will do, they'll give you this, what we have, one of our form paragraphs that lists, okay, you didn't file the detailed description, and it'll essentially go through each area in which you need to correct. So we talked about in terms of making sure that the little things, if your application is filed properly in terms of getting past all of the grammatical errors or the spelling, if your application really is cleared of majority of those things, it affords you it shortens that process, hopefully, of moving the case to final resolution. But if we're constantly going back and forth, and I've seen it many a times where a pro se independent inventor has filed an application, and it's so many things that are, and again, I'm not advocating for patent attorneys or not. I'm just saying in terms of it, a lot of times there are many problems within that patent application that a lot of times it may not even center around what the invention is all about.
Mm.
Now, and at the same time, I've had applications where the written description does not coincide with what's being claimed. The application may be a one or two page written description, but they have claimed everything that is possible to make a computer network with and the description does not even go anywhere near what is being claimed by the inventor, claimed by that invention. So it's in my opinion, it's so important. Examiners can distinguish between those two. Now, but again, we also within the patent office and on that link, it'll show where we have different particular areas within the office that can work with an independent inventor to help maybe guide them through this process, give them the information necessary in order to properly, and I say that term properly kind of loosely, to help them throughout this process. Now, and it's also essential, and Doug, maybe before because we're getting short on time, we haven't talked about the interviews.
I was just going to bring that up, because once this application's filed, we'll get an office action, which is the office action is the patent office responding and pointing out what is or isn't patentable. That we could spend hours on an office action.
Absolutely.
But the interview is, in my opinion, a critical part of the success that you will have in the patent office. And if you could describe, what is an interview, and then what you hope to accomplish, and how a good interview is supposed to go. And I will share this with you now. A patent attorney, patent agent, inventor, don't call the examiner and tell them why they're wrong. That is not going to work. It is a conversation. So, William, if you could, how do you see an interview going, and what do you look for in those?
And Doug, you're so right. It should be a conversation. And I've said in interviews, as a junior examiner, and when I first started, and it probably wasn't a good example to me, a young examiner, and seeing my primary and the attorney really go at it, and so I learned from that situation in terms of to make sure that the interview is a productive as well as a positive environment. Yes, we're going to probably disagree on a lot of things, but what I try to do is important is that let's try to find first of all, what do we agree on? And then we work from there to see, whether or not, because, and to be honest, every filed application may not be patentable, but we need to be clear. And sometimes again, and we talked about this yesterday, a written office action doesn't necessarily provide, sometimes may not necessarily provide what the examiner may be trying to convey. So that interview gives you an opportunity to explain whether it's, look, I've looked through your specification, and I've tried to see if I can find any type of allowable subject matter that distinguishes over any type of prior art. Well, to me, that's easier. That's better than putting it in the application, because then maybe the patent attorney or the examiner or the applicant, the inventor may say, okay, but can we look at this particular area? Most of the time, and I advocate that with my examiners, and right now that we have so many ways in which an applicant can request an interview. You can do video interviews. You can do right now under this particular environment, we don't have the in person within our office, but this is as good as it's going to. And to be honest, I like this too, but not only with interviews, Doug. One of the things that I also do with my examiners, and I did that as an examiner in regards to when my examiners write office actions. Sometimes it's good to explain what you see. Make suggestions to the applicant or the attorney to say, this is what I see you can possibly do. This particular piece of language might overcome my prior art. Let's look at that. If you do this, and the interview, majority of my interviews have all, I would say, most of the time they end up positive, and I try to convey that to my examiners. And I said this yesterday. Environments like this, seminars like this, when I first started doing outreach, it really opened my eyes in terms of what you guys really do, patent attorneys as well as independent inventors, how much time and effort. And so I will have an art unit meeting after this. Actually, I have one at 1 o'clock today to kind of talk to my examiners of the importance of what, you have people out here like yourselves that are literally concerned about what we do. So your office, your job is not just, okay, I want to get a count. And you know what I'm talking about, Doug. Mm-hmm. It really is to make sure that we guide that applicant, that patent attorney, to work together in order to get to hopefully a valid patent or final resolution of their application. But again, going back to interviews are, to me, the lifeblood of what we can do in terms of communicating better with one another.
Yeah, it's interviews should be and I don't know any other word to use, a negotiation of the claims and of the allowable part of this application, assuming it's there. The example, going back to the rollerblade, roller skate example, if the particular application happened to use the term truck in it, an examiner could easily say, well, the rollerblade is not patentable because roller skates have a truck. Right? Then the conversation could sound something like this. But what if we said, hey, a truck having a linear arrangement of wheels? Oh, okay, that's okay with me because that's not a roller skate. Hey, make that change in this thing. That's how the interviews are supposed to go. Yes. William can't tell you this, but I can tell you this: the odds of getting a case allowed rise dramatically if there is an interview process involved. I mean, it is. That's just they just do. And that has been my experience. The patent office won't tell you that. They can't. But I'm telling you right now, do interviews. They're critical to this process.
Yeah. It's to be honest, it really is a part of the examining process. It really is, and I tell my examiners that it's important. If you don't even have if you have an application that you are having difficulty understanding, and this is at the beginning stages of the office action, why not contact that attorney?
I can tell you this, anecdotally, I am getting more emails from examiners with questions or comments in them. It's I guess that's an interview because I get an interview summary from it, but it's a more informal than normal. But it sounds like this: hey, can we make these amendments to claim blank? I would allow it if we could. I can do it by examiner's amendment. I'm getting more and more of those types of things. So the point of that is the patent office wants to issue patents. You just have to help them do that. They're not in the business of rejecting. They're in the business of examination. And that is, and I have found it's not a fight. And because the patent office is the only entity that can grant a patent, calling and yelling may not be your best strategy for that.
Yeah, and it's to be honest, it is, and I've seen where it just doesn't move things forward in any way. And so that's one of the things. One of my I wouldn't say issue. What I really try to advocate is just to make sure that the environment that when we're interviewing is much more trying to work together. Even when I would sit down in an interview, I actually would sit as close as possible to the attorney, and try not to, where I'm at this part of the table and you're on the, because we're really trying to figure out things together. If we're really trying to, and I'm not saying trying to move it to a law, but we're trying to resolve issues. And if I can also, one of the things that that I really like when an attorney at least gives me, when we're about to have an interview or prior to an interview, make it clear on what we're going to discuss.
Mm-hmm.
Because it's important for my examiner and me as an examiner also to have an idea in terms of my preparation for that interview. And sometimes as a sign of good faith, whether the application necessitates a proposed amendment under MPEP 713, we know that also helps too. But again, we can at least have a starting place in terms of our discussion, or whether or not the details of what you'd like to discuss will help move us into whatever direction, whether it's moving into an allowance or moving into final reject. But we want to make sure that at the end of that interview, issues are at least being resolved or been resolved.
Let me ask you this question quickly. What is your opinion of the proposed amendments, proposed response given to the examiner prior to the interview? Does it help or hurt, or is it better to have sort of bullet points of what the interview should be? Or do you like to actually see, and maybe it's case by case, do you actually like to see what a proposed response could be? It's not officially filed. It's just, here's a draft, let's talk about it.
Yeah, and it can go either way, depending upon the case. But, sometimes the proposed amendment as well as a response, because it gives the example. If we are truly trying to move forward into whatever direction is going to go, that can be a starting point in terms of the discussion. Mm-hmm. So then now the examiner can sit down and say, okay, so this is, he or she are saying, they're saying, this is what I like to address in terms of page such and such in the specification, or this is how it coincides with the proposed amendment.
Gentlemen,
it really, yes.
I'm sorry to interrupt, but unfortunately we've ran out of time. Mm-hmm. Very informative discussion. I wish we had another hour, but
yeah.
I need to wrap up at this point. I'd like to remind all the participants the recording will be sent out to you later today. We will also be sending out a survey, so please let us know your comments on this and how we can make future webinars more interesting and more informative. Please check the SCRA website for upcoming webinars. And actually, Path to Patent Part 4 is coming up on August 4th at 11 a.m. So please register for that. And thank you all for attending the webinar. We hope you got great value from it. And William and Doug, thank you so much. Really appreciate you taking time to share your knowledge with us. I'm sure it's been very helpful. And the big takeaway for me is, the patent office is a partner and they want to work with us, and we need to try to work with them and find those common solutions. So hope we all find success in this new year and patent some wonderful inventions.